Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
You are once again welcome to PENDREAM TV, the only channel that brings you the best and latest updates in politics. If you are new here, please don't forget to subscribe to the channel, hit the notification bell, like and also share to other members to watch as well. You can equally leave a comment at the comment section after watching, or send us a voice note on our WhatsApp number, which is 0277 128 777. Thank you.
The point we raised, but was it necessary to discontinue all these cases almost around the same time? So it did appear like he was waiting to do this. Maybe let some of the cases continue, those ones you feel strongly about, maybe you can discontinue them. But about 7 or 8 cases,
but look, I want to look at the timeline. You come in on Wednesday, Friday, you determine that the ASEAN case should be withdrawn, and the next day the guy is given appointment as Bank of Ghana governor. I mean, look at that.
So that's a real concern. A flurry of cases dropped at the same time. Couldn't you have managed that better?
On any day, I would rely on the credibility of Domic Ayeni than Godfred on any day. Because Domic Ayeni has been on record to prosecute his own government appointee, his colleague. True or false?
That's Abu Gapele.
Godfred is on record to have discontinued the investigation of a colleague. True or false?
Which colleague?
Sisidapa. So on any day, I will rely on the judgment of Domic Ayeni as against that of Godfred. The next point is this, that as lawyers, we have different perspectives. If one lawyer thinks that witness tampering is repugnant, it goes to affect the credibility of the case in court. His conclusion on the case will be different from another lawyer who doesn't see anything wrong with that. And it was clear in the Jakpa case that what the Attorney General did in some jurisdictions, he would have even been debarred. In very serious jurisdictions, he would have been debarred. So, if you have such a case before you as an Attorney General, hearing your predecessor saying that I am under pressure from the President and the Kenoforata to nail Atuforsen. If you hear that,
what did he say that? Where did he say that?
Why didn't you listen to the tape where the conversation between he and Japa, and you realize in that conversation you heard him insult the people from Central Region. You know, I don't want to repeat those things. That they want a by-election there, and that the people of Central Region are what I don't want to repeat those things.
The content of that tape went before the judge.
Let me talk.
Okay, sure.
So when you call a witness and you subject that witness to such discussion, and you even told the witness to lie on oath that he is sick and should go for medical reports, how do you expect me, if I become an Attorney General, in such a case to continue? So murky. Too murky. So I agree with him. I agree with Domic Ayeni on this matter, that you just have to discontinue. And particularly when the Court of Appeal itself had to confirm the fears of the lawyers of the accused persons, that there's no case to answer.
But that wasn't the end of the process.
Exactly.
The process could have gone up, and it did go up. Or awaiting it to be decided.
If you are listening to me in bits and pieces, you ask this question. Put what I've said into together, the combined effect of the behavior of Attorney General and that of the court.
Let me
the combined effect is that
when the matter was appealed, we did not know about the Jakpa so-called communication. So it was appealed strictly.
We are all now talking after the facts. today you are here asking me after all this. I have a bedside view of all what has happened. Do you want me not to mention them here? So leave me to do my submission. So if you now come, because all this have happened before he became Attorney General, so he has now seen all this. So what the combined effect of such a conduct, together with what the Court of Appeal has done, you don't expect an Attorney General to continue going along that side. So there's simply nothing wrong with that thing. Didn't Godfred's tenure, wasn't it marked by a lot of controversies? It was marked by a lot of controversies. There were allegations of he even tampering with the justice delivery system. There were allegations of those things when he was Attorney General.
But allegations can always come, can they?
That's why I'm saying that his tenure was marked with controversies. And giving an example of those controversies is what I have just said.
So because of that, all the cases, criminal cases was pursuing, then withdraw all of them. Why are you withdrawing some of them? And
so because of that, you are dealing with an Attorney General whose tenure could not be described as glorifying. So a new Attorney General comes. Didn't we even hear in one of the cases the prosecutor, the prosecutor or investigator wrote in the file that it shouldn't continue?
No.
Is it the Isiama case? What Ayeni said,
yes.
But AG said former.
No, I am saying that. I am saying that.
Bring the memo.
I'm saying that.
I'm sure in the next few days. I mean,
yeah, that's the challenge. That's a challenge to Domic Ayeni, and he has to produce it.
Bring the memo and
so if you go and he said that when he entered the office, I just told him when I entered the office, I saw road crashes, pedestrian road knocks down. He says that when he entered the office, he saw that memo.
Yeah. And he was
so
you should bring it out.
If I saw road crashes, pedestrian road crashes, and I moved to the fault, why wouldn't he also, when he saw that, also deal with us the same way? There's logic. Simple logic. Now, Godfred has come to deny. I think that the onus now lies on Domic Ayeni to produce it, and I agree. But once he is in the office and said he saw that, he's bound to take the decision he has taken.
How? Which law says that?
No, but the law allows him to do what
he said he's bound. He's not bound.
No, but he's
not bound by the recommendation of a career.
Yes, but it's a matter of conviction.
I want him to choose his words.
It's a matter of conviction.
No, but he's a lawyer. When he speaks like that, those listening will think that as the Attorney General, when you receive a memo, whether through or not, when you receive a memo, you are bound to, as it were, act based on the recommendation of the memo. You can choose to ignore the recommendation. So please, let's be frank.
So the point is, Godfred chose to do otherwise or think otherwise of the memo.
Well, if it did exist. At least from what he said, it never came to him.
He decided not to ignore it. And Ayeni is the one who has the power now, and the laws allow him to so act, and he has acted. But let me begin again this way from you. Of course, it was novel to see this Attorney General provide reasons for his actions. In the past, we never really saw that. I saw Godfred trying to say that there were statements issued here and there. But the manner in which it was done, it was the first time we saw an Attorney General provide reasons for his actions. Reasons you may agree with or you may not agree with. Will you say that the reasons he's given or the fact that he's agreed to open up and provide reasons is generating more controversies than it would have been if he had kept quiet?
This is the first time that an Attorney General has subjected himself to question and answers regarding his decision not to prosecute. This is the first time. And so that may correct what Domic is saying. There were only statements, but this is the first time.
And we couldn't interrogate the statement.
You couldn't, yes. This is the first time
you Attorney General interrogate the statement, but not him.
No, yes.
This is the first time Attorney General has presented himself that asked me why I did what I did. This is the first time, and he should be commended because according to him, he thinks that, and it's still about philosophy, he thinks that in a democratic society, even though he's not bound to have gone out there to do what he's doing, but he thinks that the people need to know democratic governance. Apart from that, he thinks that he must provide justification, reasons, because of discretionary power, which has been spelled out in the Constitution, and what you should do. So again, it's about a philosophy of how he thinks his tenure should look like. And so this is the first time. And if you are asking whether that is why we are seeing more of the questioning, I don't think that if he didn't do that, there still wouldn't have been questions. Because the opponents would have still come out to say that what you are doing is, and once the opponents speak, what you are doing is to free your people. And once they speak, the minorities speak, definitely become new. So that is the answer to your question. That whether he did it or not, it will still be a topic for discussion. But did he do what was needed to be done? The answer is yes, because you needed to carry along the people of this country in your attempt to want to sanitize the Attorney General's department. I heard Godfred say that they never, as it were, discontinued cases against the MPP people. Tell me, did the NDC engage in such frivolous prosecutions? So when they came to power, they never met anybody in court coming from the MPP, because we did not engage in frivolous, prosecution of our opponents. But if you engage in frivolous prosecution of your opponents, then the outcome is what we are seeing, where even the courts would say that there's no case to answer, and you are still insistent that the current Attorney General should go along with it. And so, if you have no case to answer, and if you have no case in court, you couldn't have come to meet MPP people in court so that you can discontinue. Because we, on our part, did not engage in frivolous prosecution of our opponents. So that's why he never came to meet that. But when you had the opportunity to even prosecute your own, you failed to do it. And so when people vote to change a government, in fact, they are telling you to hold your opponent accountable. Because if you are left to continue, you hold your opponents accountable. That's one of the reasons why people change government.
So that you don't have to hold your own people accountable.
Oh, you don't understand me.
No, what he's saying is that it's easier to hold your opponents accountable than your own people.
So, in fact, there are people who are even saying that if Mahama comes and doesn't do anything at all, but is only able to hold these people accountable, they are satisfied.
Who are these people?
You are your cohorts. And so they shouldn't be worried at all. You have not done it, nobody is coming after you. We all know Ken Ofori-Attah's conduct in this country. We all know it. You people, most of you, when we meet, after the program will go down, they say, Kuntun Kunuku.
Don't.
This man has caused problems.
Don't say that.
Most of you tell me. You say it in
I haven't said anything.
He hasn't told you.
I haven't had any discussion.
Me and you have not discussed that.
Please,
but
so
I know most of you.
I don't know.
After we finish the discussion, we'll go down. They say, hey, Kuntun Kunuku. This man. Kuntun Kunuku. So you know.
I don't know.
In your hearts of hearts, when I say you, generic, you MPP know in your hearts of hearts that he has a question to answer. But probably you may be complaining about the way and manner the raid took place. But you are the last to even talk about raiding.
But no,
you are the last.
The issues are quite connected. So I want us to stay on track with them. So we're dealing with the AG. We'll get to the OSP.
Yes.
But the other point is that, Amaliba, before I bring him in, that does this not set a precedent where, for example, NDC will prosecute some cases before maybe he leaves power someday? An MPP comes,
2028.
MPP comes, the Attorney General also gives similar reasons and then frees the people. Wouldn't that be a dangerous precedent, and wouldn't that affect our quest for accountability as a people?
If that were to be the case, then I would say that it's a wrong precedent. But it's a very good precedent if you have an Attorney General who, in his handling of these cases, totally misconducted himself. Totally misconducted himself. And never even, when a judge advised him to stay away and allow his deputy to continue with the case, you heard those advice in court. He's the first Attorney General who has received such an advice. First Attorney General. So it is not just about discontinued matters, but you must have good reasons for discontinuing those matters. And I've told you, Godfred did not cover himself in glory when he was in the Attorney General's part. That's why most of these things are happening.
I see. The point about the AG coming out to explain the reasons, that should be commended in an era of transparency and all of that. And he, of course, maybe philosophically, he put that under 296, that he exercises discretion. The law allows him to keep it to himself and just move on. But he doesn't see how he can be candid when he doesn't explain or is not transparent. That should be something we should encourage going forward, even though it is not the requirement of the law.
I absolutely, I agree. And I think I commend him for that. And we need that kind of exercise in our quest for, growing democracy. So I highly commend the elected Attorney General for that. And I hope that other Attorney General who will come will follow suit and also, as much as possible, give Ghanaians reason for taking some of these discretionary measures. And it has helped us to really understand his thinking. So for instance, in the case of Judge Crayson, when he was asked, he said that his lawyers said they were confident that we were going to win the case, they will go on. Really, we now know from the AG the kind of conversation, the kind of people he's been listening to in making a decision as to whether he will prosecute a case or not. So with the others, yes, clearly you can say that he's listening to them, and there are people who probably told him that, look, we are unable to win this case if you don't come in, and so please withdraw them for us. And for us as Ghanaians, going forward, it will help us in decision making as to who we want as a president, who we want as the leader. It's interesting that in his explanation, he also tried to absorb the president in all of this, said that the president had no idea and the president had no...
They said the president didn't tell him or instruct him to do it.
The president didn't tell him. It means that he never discussed with the president, or the president, he discussed, the president said,
No, maybe it's your work. If you think that's fine, go ahead and do it.
It's just interesting.
It's your work. I'm not a lawyer. President will say, I'm not a lawyer. If it's your work, if you think that's right.
From what he says, it looks to me that he did not even engage the president. If he had engaged the president, he would have told us that I engaged the president, but he asked me to go ahead.
But indeed, he took full responsibility for it. He said he was fully responsible for the decisions.
I believe that the president was aware, the president knew about it. Because why not? Why is it that the day after he withdrew the charges against Johnson Esiama, the next day the president makes him a governor of Bank of Ghana? Look,
maybe the appointment was waiting. Maybe it was going to come anyway.
Come on, my brother. Let's be true to ourselves. The president knew. He's always been aware. And the cases are cases he has personal interest. I mean, personal interest in the sense that they are his friends, they are his colleagues, they are his NDC members. So the president was aware. They planned this. And that is why, even in some of the cases, only the people he wanted to give positions to, only the people who are deep in NDC were let off. There are some of the cases which are still pending. You know that. In the case of Johnson Esiama cases, there are some of the defendants who are still in court. Okay, because they are not deep NDC members per se.
No, but I think that the reason he gave us that the reason for Esiama's involvement in the case was not tenable.
Oh, my brother.
Because
the
300 million had been paid.
NDC man, he wanted
the 300 million had been paid. And the 150 million was still generating interest. So the matter was, the loan was performing.
Again, that is different. You see, in our criminal law, and Amaliba will tell you, if you commit an offense, it doesn't matter whether you pay back or not. The offense is offense.
No, he said that the money was lost. But the memo, the so-called memo,
but you see,
the so-called memo, he said, suggested that the money was not lost. So in the first place, the case was not properly grounded.
How? The case was said that the state had lost that amount of money. They are claiming that it's not lost. Go to the court. Let the court decide. Put your evidence before the court. Let the court make that determination.
So the point is,
in your case,
if there is evidence before you,
yes,
that this was what happened, and so the money was not lost per the memo he saw, and I'm sure he would have engaged
So
the author of that memo. We are waiting for the memo.
We are waiting for the memo.
No, yes, but I'm sure he would have, if indeed that memo exists, I'm sure he would have engaged the person who authored the memo to get some more understanding. If you are convinced that the money was not lost and all of that, will you say that you keep the matter in court, you know, causing expense to the person and even your own self, the state, until the court determines it many years later?
But you see,
when you could withdraw it because the facts available to you are different.
Yes, the truth, I mean, as a lawyer, is that if you are conducting a case, in fact, he made a point which I agreed, even the Legal Profession Act requires that if you have exculpatory information,
yes,
you're supposed to give out, and then if you have to settle the matter, withdraw the matter, you do. But here is a case that there is no such evidence. I mean, he has said it, we don't have the letter, but the case has been traveling. The case has been going on successfully, okay? And some of them, they had closed their case. So they had the case to answer. The prosecution had closed this case, and they had to open their case.
So because this matter, the matter contained in the memo,
yes,
because it was exculpatory.
The matter, the memo.
I'm sure we will see. If indeed it does exist, that's why I keep qualifying.
It doesn't exist.
If indeed it
doesn't exist.
No, but he says it exists, so it may come up. So once,
I hope they don't go and procure anything to.
No, let's assume that.
I mean, what are you afraid of again?
So
if they don't procure anything,
if this is,
because it can happen, they can procure a so-called memo and say that this is the memo.
No, but I see, if we say so, then
but anyway, you go ahead.
We can't make progress.
Okay, you go
because
ahead.
anything they bring, we may say it is being procured.
Exactly.
Okay, so this could be exculpatory, but he's saying that the charges were trumped up. If they were politically trumped up, that could maybe explain why this was suppressed. The matter of the memo was suppressed because if it came up, it would mean that the man would have nothing to answer.
Well, let's wait.
So let's wait for the memo.
Let's wait for the memo. But I think the last point that I wanted to make on this, okay, Amaliba kept saying that the AG had, the former AG had issue with the court and that he gave some information. Look, when the matter of the Attorney General's engagement with Japa came up, the court had to decide whether the information was really what it was, what they had put out there. Look, the NDC is good at propaganda. Amaliba, were you once the propaganda secretary? You know, I think
he was director of legal and director of conflict resolution.
Sure. They are very good at propaganda. So they put the information out there and make it look as if the AG was engaging in some illegality. The court, and that is the last bastion of our democracy, the court had the opportunity to listen to the tape over and over and over. And the judgment, yesterday, the Attorney General read, maybe for the benefit of our viewers, let me just read just five or six lines. This is what the judge said, that after listening to the conversation between A3 and A1, the issue of whether the AG actually told A3 to implicate A1 is not borne out by the evidence on the exhibit. The evidence on the exhibit is the tape. Okay, it's not borne out of that. And these words were uttered by A3 at about minute 9 to minute 10. In the same vein, the declaration that A3 was innocent and going through ordeal, but was asked to help make the case of the AG better, was not made by the AG, but was made by the A3, to which the Attorney General responded at minute 10:20, I am not asking you to help me. If you take your time to listen, so this is a gentleman who was putting words, you know, we're having a conversation, I say something, and I want you to assume that it's coming from you. The court said, look, what you are saying is not borne out by the evidence, it's not borne out from the tape that I have heard over and over and over. So let's not try to
in the first place, must that conversation be had at all between an Attorney General and an accused person?
I mean,
in the first place, must that happen?
I think the Attorney General made a point yesterday as to why he called the guy. That's another
There's
argument.
no reason for that.
If you are accusing somebody of doing something, you have to be factual. You have to be truthful. It's obvious
but
that
the
from
point
the
is
tape, what you are saying, what do people put out there was a lie.
No, but you see, the Attorney General could have prevented all of this. if he did not engage a gentleman in that conversation. And you know, as
conversation was going
that
a
even in
certain
civil
way.
matters, you are not even. It's not even proper for you to be engaging
Without the lawyer on
client
the other
of
side.
without
Yeah.
a lawyer. It is a criminal matter, and that is unethical. That's what Ayeni and Co. and the NDC have been saying. That alone creates some difficulty. For example, asking the gentleman to tell the court he was sick. I heard his explanation yesterday. But all of that in the court of public opinion, which is key, all of that will not look well.
But you see, there's a difference between the court of public opinion and the court of law. Because if you are prosecuting somebody, the court of law will look at the facts as they are.
No, but so the court of law had reason to pronounce on that aspect of it. That's why the judge, Ifiasewa, said that he strongly advised that Godfred Domic steps away from the case.
But the point is that the facts, the kind of issues they wanted to put on the AG did not exist, and clearly from her.
But would you agree that the engagement with the A3 was unethical? Would you agree?
Oh, I think as a lawyer, I mean, I can agree that
and the AG ought not to have found himself in that position.
Yes, I mean, I'm sure he will sit back and say that I shouldn't have done that. But it doesn't change the fact that the kind of things they said he did, he didn't do it. He didn't tell him to help him, and he actually said in the tape that I'm not asking you to help me. This is something that we need to understand that it never happened.
Our point
this is a big issue on 97.3 City FM. We're looking at the AG's withdrawal of some cases and the entry of knowledge prosecutor in others. The matter which is taking our time really is the Japa case, the Atoforcing and Japa case. I mean, the Republic versus these two people.
We have in the Thompson and all of these cases.
And quite a number of cases.
Millions and millions of dollars. What was his reason for withdrawing the case against the Thompson?
So my guests this morning are John Daku, Member of Parliament for Swami, Amaliba, Director General National Road Safety Authority, and also Director of Conflict Resolution of the NDC. Franklin Kojo join us soon, and Niaiko too also join us soon on this.
Appointment of Johnson Esiama. I don't know how whatever was happening in court can prevent his appointment.
The fact that he was, of course, you are innocent of the
only guilty. Yes, it is
but
only when there's a
conviction.
conviction.
Works in a funny way. They don't want people with questionable character and people who have been engaged in A, B, and C to be found around this. And it wouldn't have been good for the optics if your governor was standing trial for causing financial loss to the state to the tune of over 300 million, and also giving money to a bank that was not supposed to be, and all of those issues. Those would have created some matters, upon his head.
I agree, but he was not proven to have done those things either. And so the appointment would have still come, irrespective of whether the matter is in court or not. And I'm trying to distinguish or detach what he's saying from what Domic did by saying that because they wanted to appoint him, that is why.
But will you say
that
it
was withdrawn?
The dropping of the case and the appointment the following day or so, would you say that was just coincidental?
Both parties are doing their work. Appointing authorities are doing their work. Domic is doing his work in the Attorney General's department. If by coincidence it happens that after I've dropped this case, he's appointed, that's a different ball.
It would have been interesting if he had been appointed before the case was dropped.
And I'm saying that
that would have been very interesting.
That one would have been the real issue.
Oh, this is
that worse. you are
dropping if he has been appointed before the case was dropped. Would have said because the case is appointed, it's been dropped.
That's more serious matter.
You are watching it before you put him there.
But we all know, he knows, and we all are lawyers here, that until you are proven guilty and you are not being convicted, so it's not debarred from holding public office. And so, if we want to go legal, let's go legal. And then you spoke about the fact that public opinion is not important. What is important is what happens in court. No. The reason why there's credibility or there's what people attach importance to our justice delivery system is perception that when you go to court, the right things will be done. And so if those who are to patronize the courts begin to feel that the justice delivery system is being manipulated, those people will not go to court. So public perception of the judiciary is as important as what is happening in court. What is happening in court is legal, but public perception as to what the justices too are doing is right is also important.
That's why you're
so two of them, two go together. Two go together, and nobody has lied to that. If people see that you pass a judgment saying that your birth certificate cannot prove you as a Ghanaian, people know that judgment is wrong. You don't need a lawyer to tell you that. And so the justice delivery system must acquit itself in such a way as to allow the ordinary Ghanaian also have confidence in the judiciary. So don't say that public perception is not important. It is important, particularly when the judiciary strives on public perception. Judiciary, all that they do is predicated on public perception. If public perception of them is low, then our judiciary is gone.
You agree that there are times the public just doesn't understand what happens. I mean, it may sound different to the public, but when you look at the law itself, the judge may be right in ruling that way. But because the public doesn't understand, you say, this is it. How can this be so? Meanwhile, that is the law, and the judge is just following the law.
And that is why lawyers are there to explain, and the public would then take it on. You see, I am saying that the day we get to a point where the public has no confidence in our judiciary, you know how the common law came about. There were other courts. Weren't there other courts? But those courts lost their credibility because perception of them was bad, and everybody started gravitating towards the common law. That's how the common law became common law. And I'm saying that in Ghana, when we get to a point when the public perception is
but we're not talking
the
about
public
the perception.
You brought about that. No. The public perception is low in our judiciary. When the public, now let me finish. The public perception is low of our judiciary. That's the end of our judicial system. But your point is right. There are some things which are technical. How do we get the public to understand that? And that's why I'm saying that lawyers must then play that role, critical role of explaining these issues to the public. But you must carry your public along in the judicial system. You must, because they are the ones who patronize the courts. And if you don't do that, you leave them behind, your court system would break down.
I see.
Thank you for staying tuned. PENDREAM TV really appreciates your time, and once again say God bless you for the good work you are doing. We much appreciate your time every day, every night. Without you, we are nothing. God richly bless you all. Thank you.
Dedi kama mamena PENDREAM TV ase. Na so far so good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.